Hello, I'm Helen Rose and I'm an associate at Bristows in our IT and data protection group. In this video I'm going to look at monetary penalty notices issued by the Information Commissioner's Office and how those monetary penalty notices show how the Information Commissioner is using its enforcement powers. The ICO has had the power to issue monetary penalty notices for breaches of the Data Protection Act since April 2010, and in May 2011 that power was extended to cover breaches of the Privacy and Electronic Communications regulations too. When does the ICO have the power to fine? The ICO can choose, and it does have the discretion to fine, if the following criteria are met. Firstly, there has to have been a serious breach of the Data Protection Act or the PEC regulations. Secondly, the breach must have been of a kind likely to cause substantial damage or distress. And thirdly, the breach must have been deliberate or reckless. And when I say reckless, I mean that the data controller knew or ought to have known that there was a risk that the breach would occur. Secondly, that he knew that the breach was of a type likely to cause substantial damage or distress. And despite that, no reasonable steps were not taken to prevent the breach. It's worth noting here that distress in this context means sort of harm or injury to feelings or anxiety, that kind of non-financial damage. And it's not necessary that the likely damage or distress should actually have materialised as a result of the breach. So, for example, if someone's sensitive medical records are lost, but the individual isn't aware of it and the records don't come into the possession of any third party, that wouldn't stop the ICO from issuing a fine on the basis that it was a breach likely to cause distress. So if those minimum criteria are met, when will the ICO issue a penalty and for how much? The ICO will decide whether it's appropriate to issue a penalty for the breach, and its guiding light in making that decision will be the underlying objective of its power to fine, which is to promote compliance with the law. As a first step, the ICO will look at the particular breach, for example, the number of individuals affected, the duration of the breach, and the type of data involved. It'll also look at behavioural issues to do with how the data controller has acted. So, is this the first of a series of breaches that's come to the ICO's attention? Does the data controller have a sort of cavalier attitude to compliance? Does it have compliance procedures in place within its organisation? And external factors which are relevant to promoting and encouraging compliance with the law will also be taken into account. So it's perhaps more likely that a monetary penalty notice will be issued if the breach is of a kind that's particularly prevalent and the ICO believes that issuing a penalty to this particular data controller will encourage compliance by others. And once the ICO has decided to fine, it will determine the amount of the monetary penalty notice, and that's a five-step process. So the first step is to allocate a seriousness rating to the breach. And so the breach will either be serious, very serious, or most serious. And there is a sort of band of penalty amounts attached to each of those categories. So if the breach is categorised as serious, the sort of band is £40,000 to £100,000. If it's very serious, the band is £100,000 to £250,000. And if it's most serious, the range is £250,000 to £500,000, so the maximum. The amount of the penalty will then initially be placed at the middle point of the range for its category. So if the breach has been determined to be serious, the initial amount of the penalty will be set at £70,000, so the middle of that £40,000 to £100,000 range. And the ICO will then adjust upwards or downwards to take into account the particular circumstances of the breach. For example, the number of data subjects affected. The next step will be to adjust for aggravating or mitigating factors, which are factors that relate more to the behaviour of the data controller as opposed to the breach itself. So mitigating factors might be that the data controller has cooperated with the ICO's investigation, that it has voluntarily reported the breach, or that it's taken steps to make amends to data subjects who are affected by it. Step 3 is about looking at the financial circumstances of the data controller. So the amount of the penalty might be adjusted upwards or downwards. For example, if the data controller is less wealthy, it might be lowered to avoid undue financial hardship to the data controller. Or if the data controller has greater resources, it might be adjusted upwards to make sure that the penalty is an effective one for that data controller. And the fourth step is for the ICO to consider whether the amount of the penalty it's arrived at meets the underlying objective of encouraging compliance, and the amount might be adjusted upwards at this stage to ensure that it's an appropriate deterrent amount. And finally, the final step is for the ICO to take a step back and look at the amount of the penalty to see whether in all the circumstances it's proportionate, reasonable and consistent with penalties that have been issued to other data controllers in the past. And it's worth noting that the initial seriousness rating for the penalty within and the banding that applies to that isn't set in stone, so the adjustment to take into account other factors or aggravating or mitigating factors may move the penalty out of its initial banding. And once the ICO has decided on the amount of the penalty, it will notify the data controller of its intent to issue a penalty, and the data controller has the opportunity to make representations before the ICO comes to a final decision. Moving on to look at the statistics and the results of this process in practice, we can see that the trend generally is for greater enforcement, both in terms of the number of monetary penalty notices issued and the amount of the penalties issued. So in 2010, only 2 monetary penalty notices were issued, and that's perhaps not surprising given that the ICO only had the right to issue penalty notices from the end of April that year, and it was just getting used to the new enforcement regime. But then in 2011, 7 MPNs were issued, and that rises quite steeply to 25 in 2012. And so far this year, 11 penalty notices have been issued, so it'll be interesting to see if that trend for greater enforcement continues this year. The statistics here also show that the average value of monetary penalty notices has increased or tended to increase year on year, as has the value of the highest value monetary penalty notice issued in each year. In terms of the highest value monetary penalty notice issued in 2011, you'll see that we've shown on the slide a figure of £200,000. In fact, although that was the penalty that the ICO decided the breach deserved, unusually it was reduced to £1,000 to take account of potential financial hardship to the data controller in that case. And that was the ACS case, where the data controller was a sole practitioner solicitor who had failed to take reasonable security measures to prevent access to names, addresses and downloading histories of internet users which were on his systems, including downloading history related to adult titles, so that was quite sensitive personal data. And in that case, the breach was actually the result of an attack on the data controller's systems by hackers. But the ICO said that partly because the data controller's practice involved bringing claims against illegal downloaders, he ought to have anticipated that kind of attack, and he ought to have taken reasonable steps to prevent that particular kind of attack. And in fact, his security systems were only suitable for home domestic use. They weren't business security systems. The highest value penalty notice issued to date is the £325,000 penalty imposed on Brighton and Sussex University Hospitals NHS Trust in 2012. And that's the only penalty that has been determined where the breach has been determined to belong in the most serious category. That was a case where 232 hard drives that had previously been used in the hospital ended up on eBay. and they contained, in readable format, thousands of sensitive medical records for patients of the hospital, including things like results of HIV tests. The ICO said the Trust should have applied the highest possible security to the destruction of the hard drives, but instead it didn't have a contract with the contractor who destroyed the hard drives. It didn't prevent that contractor from subcontracting, and so the work ended up being done by an individual in relation to whom the Trust hadn't assessed that individual's reliability and didn't monitor his compliance with data protection principles during the process. This next graph shows the sectors which have attracted the greatest number of monetary penalty notices. As you can see, by far the largest number of penalties have been imposed on local authorities. And the next most penalised sector is health and care trusts. So of the 45 monetary penalty notices issued to date, 21 of those have been issued to county councils or district councils, and 9 to health or care trusts, so over half the penalties to those two sectors. That's probably not surprising in light of the volume of personal data handled by local authorities, and particularly sensitive personal data. In addition, local authorities are encouraged to notify breaches to the ICO, and NHS trusts are required to notify data security breaches in their accounts. So it may be that these breaches are coming to light more than those that might be occurring in the private sector. There's some indication that this trend might change to some degree in future, so that we'll see greater enforcement in the private sector. In particular, the ICO has dedicated resources to enforcement against those who send unwanted text messages or make unwanted marketing phone calls. And of the 11 monetary penalty notices issued this year so far, 4 of those have been issued for breach of the PEC regulations rather than for data protection breaches. The graph shown in this slide tracks the amount of each monetary penalty notice issued against the number of individuals, or in the case of the PEC regulations, the number of records affected. And one type of data security breach that gets a lot of publicity are those where a large volume of data has been lost. So we remember the headlines when HMRC lost child protection data related to 25 million individuals. And as you can see from the graph, a breach involving a large number of individuals is likely to attract a high value penalty. An example is the Brighton and Sussex Hospitals Trust case, which I mentioned earlier, where thousands, or around 65,000 records were lost. However, the cluster of data points near the lower end of the number of records axis also shows that a significant number of monetary penalty notices have been issued where the breach affected a very small number of individuals. And those are cases where the ICO looked at the breach, and although only a small number of individuals were affected, the data involved was so sensitive that it felt that a fine was justified. And in fact, 5 monetary penalty notices have been issued where only 1 individual was affected by the breach. And an example of that kind of case is the Nursing and Midwifery Council. In that case, only 3 individuals were affected by the breach, but the fine issued to the council was £150,000. In that case, 2 of the data subjects affected were vulnerable children, and the data involved was highly confidential and sensitive and involved allegations of offences committed. And it probably didn't help the data controller in that case that the data was lost and was not encrypted. So in the light of the ICO's guidance on encryption, we'd almost expect that where the ICO looks at a case where data has been lost on a portable device or in portable media and wasn't encrypted, that a monetary penalty notice will be issued. Finally, the graph shown now looks at the extent to which, where a breach is first categorised by the ICO as serious, very serious, or most serious, the penalty ultimately issued will have stayed within the band for that categorisation. And the breaches categorised as very serious have all resulted in a penalty within the band of £100,000 to £250,000. So that suggests that perhaps where the breach is very serious, the ICO is less moved by aggravating or mitigating factors and maybe feels less need to increase the penalty to have a properly deterrent effect. On the other hand, where the breach is categorised as serious, more than half of the penalties end up above the top of the initial band of £100,000. And that suggests that one of two things, or both of two things, may be happening. Firstly, the ICO may be less or more moved by particularly aggravating factors where the breach is serious. And secondly, perhaps the ICO is increasing the amount of the penalties for some of these serious breaches in order to show its enforcement teeth and ensure that the penalty issued has a properly deterrent effect on others. I hope you found this useful. Thank you very much for listening.